Thank you very much. Thank you very much, everyone. And thank you for asking us to present. We're really happy to be here tonight and to present on this. It's a very important topic and one that I think we can't ever say enough about. And we hope that this is helpful to you in navigating the system. So maybe I'll have the next slide, Mega. So I'll just tell you a little bit about myself. I started my career many years ago as a frontline social worker at the former Queen Street Mental Health Center, and learned probably on day one of the importance of families in the care of people with mental illness and substance use disorders. It's they're so important in terms of their role in care, their partners with us in care, and also in enhancing client outcome. And we'll speak a little bit more about that in a few more slides. And I think there's probably not any family member, no matter, I think all of us as family members have probably collided with the system in some way when you're trying to actually give or receive information about a loved one when they're in the hospital, and whether that be, a hospital treating mental illness and addiction or any kind of general hospital. I'm sure everyone has stories of how the system has probably not cooperated. And I think so. What we're trying to do tonight is to help you to understand the basic concepts and protocols surrounding privacy and information sharing, because particularly with populations of people with mental health and addiction issues, I think that uh, confidentiality and privacy really rears its head. And I think that comes from a place where uh, historically patients' rights and privacy and autonomy weren't really respected. And so uh, I guess around the 1970s, 60s, the laws changed to really focus on the consumer rights that people had. And so privacy became very supreme, I guess, in terms of people having autonomy and agency to direct their care and to determine who would be involved in their care. But I think in actual practice, what happens is that for family members, they can feel very much in the dark um, when these rules are applied in what can seemingly be a very rigid kind of way. So, what we want to do is talk to you about some of the realities and hopefully give you some tips, whether you're a family member or a clinician, in terms of how you might navigate uh, the whole privacy and confidentiality world. So, if I can have the next slide, Minga. So family, what is family? I mean, these days family is defined as anyone really whom the patient determines is in their world, in their caring circle, and that can be an extremely close friend who's a family member. It may be maybe a partner, it may be an aunt or an uncle, grandparent. So it's really a very broad range, and I think that for the most part clinical teams do accept that. But there are people who have legal authority to know information, and we'll get into that. So if we could have the next slide, Mega. So again, this, family can include any person that the person identifies. And Kendra will get into the legal definition of sort of how someone who has been appointed as a family member can actually gain access to information. Okay, next slide, Mega. So I think that what's really important for clinicians to remember is that for the most part, the hospitalization is not the main event in the person's life. It is an episode, sometimes longer, sometimes lengthy, but for the most part, fairly short episode. And people leave our hospitals, and it's families that provide the bulk of mental health and addiction care for their loved ones before, after, and during the times of illness and crisis. And I had when I first started working, I worked on a very long-term ward in the Queen Street Mental Health Center. And the myth then was that these people were forgotten, they didn't have family members, that they'd been abandoned. And then I started delving into each person and understanding them and understanding their story. And I actually did a survey. And this was what would back then would have been called, a long-term, a bit of a back ward. And so all of these people were very long stay people. And yet there was only at that time 6% of those patients, and there was a 33-bed unit. 6% of those people had minimal or little contact with families, but each and every one of them did have some contact with families, and for the most part, a pretty high degree of contact with families. So that said to me at the time how important they were. And often people are connecting unbeknownst to the clinical team. And so families are very more involved, I think, sometimes than clinical teams appreciate. So they have a lot to offer providers in the form of valuable information and knowledge about their relatives. And one of the things that I do a lot of now, which is not it's not one of my favorite things I do, but we do review critical incidents and deaths. And when we're reviewing these situations, more often than not, and as part of that process, we do reach out to family members, and we find that family members have often been very disappointed because they were not contacted during the crisis time. So, for instance, someone may have come into our emergency department ill. Maybe the relative lives, not in the GTA or in Barrie, it's long distance, but still we have to make every effort to contact them because they're such a valuable source of collateral information and can give information about about the events leading up to the episode. And they deserve to have access to the information, education, and perhaps counseling if they so desire, because they're best able to support their loved ones if they themselves are also supported. But they are the ones, for the most part, people still, for the most part, get discharged into the care of families. So it's important that we as clinicians and providers connect with families and provide them with information so that we can best work together in order to help the person with their recovery journey. Okay, so next slide, Minga. And I remember one time speaking to a physician who said, if drug companies could claim the same positive results as involvement of family, can you imagine how well everybody would be doing? So when you look at actual studies of when you actually involve families in care in a meaningful way, and you study that involvement, what you see is there's better coordination of care, there's fewer medication errors because you've got more eyes on the whole situation, definitely have decreased rates of hospitalization and relapse, enhanced commitment to treatment choices because you're working together along with the family and the person who's experiencing the episode, increased rates of recovery, and it really important, decreased involvement with the criminal justice system and a better client and family experience. Okay, the next slide, I think. And so now I'm going to hand it over to Aleks, who's going to talk about the whole privacy world, and then I'll come back at the end to talk about more clinical considerations. So over to you, Aleks.
Thank you, Jane, and good evening, everyone, and thank you so much for joining us. So just to check, can everyone hear me? Yes, good, perfect. So let's talk about privacy. What is privacy? Privacy is a legal requirement, it's a professional standard, and it's an ethical obligation. And it's really the right of the individual to control how information related to them is collected, used, and disclosed. In healthcare, privacy is critical to maintaining strong relationships with patients who trust that their care providers would use that information to make an accurate diagnosis and plan effective treatment. And really, anyone working in a healthcare sector has a role to play in protecting privacy of our patients. Mega, next slide, please. So we will just go over some privacy terms that you will hear us mention throughout this presentation. So we mentioned that privacy is a right of individual to control how their information is collected, used, and disclosed. Confidentiality is the obligation of an individual to keep confidential information that was provided to them in confidence. And these obligations may be set out in law or in an agreement with the information when the information was provided. And confidentiality applies to both personal and personal health information, as well as confidential information of an organization. Security refers to measures taken to safeguard information against theft, loss, unintentional disclosure, modification, or destruction. And these measures may be administrative, technical, or physical. And you can have security without privacy, but you definitely cannot have privacy without security. Ethics is moral principles that govern persons or institutions' behavior or conducting of an activity. And ethics is really about respect for human dignity. Next slide, please, Mega. So identifying information is any information that directly identifies an individual for which it's likely in the circumstances that it could be used either alone or with other information to identify an individual. Personal health information, that's the term that you will hear us use quite often during this presentation, is information about an individual in relation to their healthcare. So any information that relates to individual's physical or mental health or provision of healthcare to the individual, any information that identifies individual's healthcare provider or substitute decision maker, or any information that relates to payments or eligibility for healthcare. Personal information is any information that could be used to identify individual and either alone or in combination with other information. And some of the examples of personal information are your name, your date of birth, your address, your email, your telephone number, and health information custodian is the next term that we wanted to mention, and that's another one that you will hear us talking about often. So health information custodian, or HIC, is an individual or organization that provides healthcare to an individual and has custody and control over personal health information. And some of the examples of health information custodians are hospitals, individual healthcare providers, so it could be your family doctor or specialist you're seeing, pharmacy, labs, long-term care facilities. So those are just some of the examples of health information custodians. Mega, next slide, please. So, CAMH Information and Privacy Office. Every organization is responsible for personal health information and personal information in their control and needs to designate individuals who are accountable for organizations' compliance with relevant legal obligations. And this is why CAMH has Information and Privacy Office. CAMH Information and Privacy Office provides privacy support to CAMH staff and patients and their families, and ensures that CAMH complies with relevant legal obligations. So we make sure that organization is implementing appropriate safeguards to protect patient and corporate information at every step of a journey. Again, we are here as a resource to staff and available to consult with staff and work with them through any questions that they may have that are privacy related. And we are definitely here as to provide support to patients and families who have any privacy questions or concerns. Next slide, please. So why is protection of privacy and in particular personal health information important? Personal health information is extremely sensitive information, and this is why it is very important that organizations are implementing appropriate safeguards to protect patient confidential information at all times. Clear policies and procedures need to be in place to assure that personal health information in organizations' custody and control is protected at all times. Appropriate privacy training needs to be provided to all agents of the organization so that it's clear how personal health information and personal information can be collected, used, and disclosed in accordance with those organizational policies and our legal obligations. If personal health information is not adequately protected, this may result in unauthorized access to, use, or disclosure of personal health information, and it may lead to discrimination, stigmatization, or even psychological harm to the individual whose information is inappropriately used and disclosed. It may also result in loss of trust in a healthcare system. So some individuals may be discouraged to seek treatment, or they may not share certain information or even provide false information to care providers, all in fear that their information may be inappropriately used or disclosed. Next slide, please. So public healthcare organizations in Ontario are subject to two pieces of privacy-based legislation, and those two legislations are Personal Health Information Protection Act, PHIPA, that came in effect in 2004, and PHIPA governs collection, use, and disclosure of personal health information and establishes the rights of individuals to access their personal health information and also to make a request for correction of their personal health information if they're in disagreement with the information that custodians have in their custody. Freedom of Information and Protection of Privacy Act, FIPA, came into effect for hospitals in 2012. And FIPA really defines the information that should be available to the public and also provides the individuals with right to access their own personal information. Next slide, please. And this is over to Kendra.
Thanks, Aleks, and thanks everyone for being here with us today. So moving into some of the legal requirements around particularly collection, use, and disclosure of personal health information. So as Aleks has told us, healthcare providers in Ontario are subject to the Personal Health Information Protection Act, or PHIPA, and it states when healthcare providers can collect information, when and how they can use information, personal health information, and when personal health information can be disclosed. And the starting point, the basic principle, is that consent is required for all three of these actions. So consent is required to collect personal health information, to use personal health information, and to disclose personal health information, except in certain circumstances. So that means that if we have a client or a patient and family members are asking for their information or want to provide us information, the starting point is that we need consent from the client or the patient in order to do that. Now, you know, there's, I think, still a prevailing myth that is floating around that healthcare providers can do that thing where they say, I can't tell you anything, but I can listen to what you have to tell me. And that that misunderstanding is because before the latest round of amendments to the privacy legislation in Ontario, that was allowed. Older versions of PHIPAA required consent for the disclosure of information, but did not say that consent is required in order to collect information. However, the last time that the Privacy Act, the Health Information Privacy Act was amended, that change was made to be explicit that consent is also required in order for a healthcare team to collect information from families, except in certain circumstances that we're going to talk about. A couple of those exceptions are around substitute decision makers. So if somebody is found not able to make their own decisions about treatment, then the healthcare team is able to disclose limited information in order to establish who is the lawful decision maker for a patient who's not able to make their own decisions about treatment. So, you know, what that means is that if somebody is found not able to make their own decisions about treatment, and the healthcare team knows that there are parents and some siblings out there, and they're able to get those people's contact information, even if the patient is saying, I don't want you speaking to my family at all, because they've been found not able to make their own decisions about their treatment, the healthcare team is allowed to call up those family members, let them know that the patient is in the hospital, tell them we need a decision maker for treatment, and have a conversation with the family members about who is going to assume the role of decision maker. Sort of along the same lines, once somebody is found not able to make their own decisions about treatment and the substitute decision maker has been identified, we often refer to the substitute decision maker as the SDM. Once the SDM is identified, then the SDM becomes the decision maker for any collection, use, and disclosure of health information if the reason for that collection, use, or disclosure is related to the treatment for which the patient is not able to make their own decisions. So if a patient is found not able to make their own decisions about a particular treatment, and let's say their parents are their substitute decision makers, and the hospital needs to collect medical records from other hospitals, for example, in order to find out what medications has this person been on in the past, and did they have any side effects, and did it help them or did it not help them, then it would be the parents who would give consent to collect those records, not the patient themselves, because the patient's not able to make their own decisions about treatment, and this collection of personal health information is to facilitate decision-making about that treatment. Mega, can you go to the next slide, please? Thanks. There are also some other situations where consent is not required in order to collect personal health information. And these ones come up a lot for us at CAMH. So in designated psychiatric facilities, so this won't necessarily apply to every hospital in Ontario, it applies to designated psychiatric facilities. A different piece of law, the Mental Health Act, says that psychiatric facilities are allowed to collect health information even without consent from the patient, if it appears that the person might need to be admitted to hospital, and that information is necessary or critical to the healthcare team to decide whether to take steps to admit the person to a hospital. So for those of you who are familiar with the legal mechanisms in the Ontario's mental health system, there's something called a Form 1, which permits, is an application for a psychiatric assessment that is signed by a physician, and it authorizes the police to go and find someone and bring them to a hospital for an assessment. So if a Form 1 has been completed in relation to a patient for the 72 hours that they remain on the Form 1, the treatment team is allowed to collect whatever information they need in order to do that assessment to decide whether the person needs to be admitted to hospital. So in that window where they're on the Form 1, because the Form 1 is to permit a psychiatric assessment, the law says they're allowed to collect any information that they need in order to make an admission decision. So to put that in very concrete terms, For those of you who have family members, whoever are brought into hospital on a Form 1, and you're there in the emergency department, the team in the emergency department can speak to you to find out what you know and what relevant information you might have about the patient, and to help that decision about whether they need to be administered. And they can do that even if they don't have consent from the patient for that. Similarly, if there's a possibility that a Form 1 may need to be completed, then the physician who's contemplating the Form 1 is allowed to collect information without consent in order to make a decision about whether a Form 1 is appropriate. However, once the decision to admit the patient to hospital has been made and the patient is admitted, then the situation changes. Now they've been admitted, we've already made that decision. And so after that point, in order I muted myself, in order to collect further information, then the healthcare team would need consent from the patient or the lawful decision maker. Megan, we can go on to the next slide. There are other circumstances where the law says we can share information about a patient or a client without their consent. That includes if there's an imminent risk of serious bodily harm to an identifiable person. We often call that the duty to warn. So if the healthcare team comes into possession of information that suggests there's an imminent risk of serious bodily harm to someone out there in the community, they are allowed to disclose limited amounts of information in order to mitigate or eliminate that risk of harm. In certain circumstances, healthcare providers are allowed to share information between them. And I've already referred to the Mental Health Act. If somebody is on a Form 1, in that circumstance, we don't need consent to contact other hospitals and see if they have records about that patient and to get their records about that patient. If someone has reason to believe that there is a child who is at risk or in need of protection, then we can make a report to the Children's Aid Society. We don't need consent from that. There are also circumstances where in legal proceedings, we may receive a summons or a subpoena for records, in which case we have to disclose them. Or if the police are investigating, there are circumstances when they can obtain personal health information without any consent. We can go to the next slide, thanks. Oh, and there are circumstances where, if someone has particular medical or psychiatric conditions, that must be reported to the Ministry of Transportation, and that also doesn't require consent. So when I'm talking about consent, there are certain legal requirements for what constitutes valid consent. So we have to have consent from the right person. So that means generally it's the individual themselves that is giving consent, but in certain circumstances, there can be a substitute decision maker. I've already talked about the situation where someone has a decision maker for treatment, and the substitute decision maker can give consent to collection of information related to the treatment. It's also possible for someone to be found not able to make their own decisions about disclosure of personal health information itself, in which case the law provides a mechanism by which typically a family member can be appointed to make decisions for them about their personal health information. Consent has to be knowledgeable, which means the person has to be informed about what collection, use, or disclosure is happening. What is it for? What is its purpose? What are potential risks and benefits to them of that disclosure? It has to relate to the information, so they have to, as I said, they have to be informed about what information is being disclosed. And of course, consent can never be obtained through deception or coercion. We have a legal obligation to be honest with patients about what's happening with their personal health information, and to be seeking consent from them in a completely open and transparent and honest way. We can go to the next slide, thanks. There are two ways that consent can be given. There's express consent or implied consent. Express consent means that somebody has actively given specific permission for something to happen. So when we're talking about express consent, that means somebody has been asked, can we speak to your family member about your care and what's happening in hospital and your condition? And the patient has said, yes, it's okay for you to call my family member and to talk to them about my hospitalization and my care. That would be express consent. Express consent can be given either verbally or in writing. So, we often use consent forms to evidence that express consent has been given. Those are really handy because it's something in paper, it's easy to find and locate, and the person has signed their name to it. But it is also acceptable to get verbal consent, which means the person can give it verbally, and typically that would be documented in the health record so that we have a record of it. Implied consent means that we are assuming, because of the circumstances or because of what someone's doing, that they are giving consent. So they haven't actively said, yes, I consent, but because of their words or their actions, or because of the circumstances, we can assume that they are consenting. An example of that that's sort of not related to personal health information is, if someone goes to the doctor's office and the doctor says, I need to take your blood pressure, and the person holds out their arm and they says, we would imply from that circumstance that the person is consenting to their blood pressure being taken because they've come to the doctor. When the doctor said, I need your blood pressure, they had out their arm in a way that shows, like, yes, I'm giving blood pressure. So that would be an example of implied consent. We can go to the next slide, thanks. In the privacy sphere, implied consent usually comes up when we're talking about something called circle of care. The circle of care is not a legal term. It's just a colloquial term that's commonly used in the healthcare space. And essentially what the circle of care boils down to is that we assume or we imply that if people are seeking healthcare from multiple healthcare providers, they will consent, or they are consenting to those healthcare providers sharing information between them for the purpose of providing that healthcare. So that's kind of an assumption that's built into our legal frameworks. Now, this applies only to healthcare providers and for the purpose of providing healthcare. So the way I often describe this is we have the circle of care. So that means you have to be in the circle, which means you have to be a healthcare provider to be in the circle. And it's the circle of care, which means the purpose of the collection or disclosure of personal health information is for the purposes of providing care. I think that's just kind of how I conceptualize it in my head. So, in these circumstances, hospitals may share information about folks. We will often, at CAMH, we will often touch base with somebody's family physician. If, somebody's admitted to hospital and we say, do you have a family physician? And they say, yeah, it's Dr. So-and-so, and here's our contact information. They have offered that information to us, so we would assume that they are okay with us, for example, sending a discharge summary or contacting the family physician to find out what's been happening. Now, the concept of implied consent and the concept of circle of care only applies if we don't have reason to believe otherwise. So we can only assume that people are providing this implied consent if they haven't told us otherwise. There were a lot of negatives in that sentence. Sorry about that. So if somebody specifically tells us, I don't want you speaking with my family physician, we can no longer assume that they are consenting to us talking to their family physician, and we would then have to get their express consent in order to do that. So we can go on to the next slide. Can't remember if that's here. We go. All right, and so I'll throw it back to Aleks. Thanks, Aleks.
Yeah, thank you, Kendra. I can take that. So, as Kendra mentioned already, PHIPAA is a consent-based statute, and that means that it gives Ontarians control over collection, use, and disclosure of their personal health information. And under PHIPAA, individuals may provide express instructions to health information custodians not to use or disclose their personal health information for healthcare purposes without their consent. So this right of individuals to withhold their consent is commonly referred to as a lockbox, and it has been in use ever since PHIPAA came in place in 2004, although the term itself was never really defined in PHIPAA. And when HIPAA was amended in 2016, this section of consent directives was added to PHIPAA, referring to the directive from individual to withhold or withdraw their consent for collection, use, and disclosure of information for healthcare purposes. So, for example, if the patient does not want the hospital to share their information with any care provider external to the hospital, for example, they may request that consent directive is placed on their hospital health record. And in that case, hospital cannot assume implied consent anymore. And if the hospital receives a request from external care provider about that individual, their information cannot be disclosed without individuals' express consent, or in situations where the information is necessary for the purposes of eliminating significant risk of bodily harm to the individual or other individuals. So that would be about consent directive or a lockbox. We can go to the next slide, Megan. So, shared provincial systems. Ontario has several shared information systems for different regions and types of information. And these shared provincial electronic systems are secure and web-based portals that provide authorized care providers with real-time access to health records of other healthcare providers. And these systems have many benefits. They ensure that healthcare providers have most up-to-date and complete record access to record of any individual and patients. They improve efficiency of planning and delivering care and treatment to the individuals. They reduce the need of patients having to provide the same information on multiple occasions and multiple times, and they definitely reduce duplicate tests and procedures and improve general timeliness of care decisions. So, for example, individuals receiving treatment in Ontario may have some of their personal health information shared through this Ontario Health Connecting Ontario clinical viewer. And CAMH has been contributing the information from our electronic health record to this provincial shared system since September of 2017. Patients do have a right of access and corrections of their information in these shared electronic health record systems, and they also have a right to withdraw consent to share their information in these systems. Can we go to the next slide, please? So breaches. What is a breach? Privacy breach is any theft, loss, or unauthorized access, use, or disclosure of personal information and personal health information in the custody of health information custodian. And every individual who handles personal health information or personal information has obligation to ensure that information in their custody and control is protected. So failure to do so leads us to a privacy breach. Next slide, please. So when a breach of privacy occurs, organizations have obligation to investigate the breach and take all appropriate measures to prevent similar breaches from happening in the future, and to notify all of the individuals affected by the breach. And as of October of 2017, in certain circumstances, individual breaches may need to be reported to the Information and Privacy Commissioner's Office as well. So breaches that organization is obligated to report to the Information and Privacy Commissioner of Ontario are when information is accessed, used, or disclosed without authority, when information is stolen, for example, a laptop, unencrypted laptop, or USB stolen, or paper record containing sensitive personal health information is stolen. Also, organizations are obligated to report breaches when a disciplinary measure has been taken against an individual as a result of a privacy breach, so individual employee, as well as when disciplinary measure is taken against individual who is a member of a professional college, such as nurses or physicians, social workers, then their professional college must be notified as well. And as of March of 2019, health information custodians are also required to provide the Information and Privacy Commissioner's Office with an annual report of all of the breaches that occurred during that reporting year. Next slide, please. This one is over to Jane, I believe.
Yeah. Thanks very much, Aleks. Okay, so now we'll return back to some clinical considerations regarding consent and privacy. And I think what's very important is that treatment teams need to have early and ongoing conversations with clients about their privacy rights and how they want their family to be involved. And I think the key here is ongoing because it can change. So someone may come in and they may say, that's it, don't talk to anybody. Do not talk to my mother, do not talk to my father, forget it. I don't want, I don't want them involved in my care. But it is important to revisit that throughout the course of care. Sometimes when people, have calmed down, perhaps they've been treated, perhaps with medication, with other therapies, or even when they continue to be agitated, they can change their mind. And I think it's in the approach. So it's important for clinicians to approach this sensitively and maybe not always take the first declaration as the final declaration. However, if they do expressly ask the team not to speak with their family, then we do have to honor that. But often, if you give the client information about the benefits of involving their family, and if you go back to my earlier slides about the fact that, it's families who, for the most part, are the people who are involved with people on the outside of the hospital. They're often living together. And often when you talk to people and say, this doesn't just affect you, but it affects your mom, and we want to help your mom to understand what's going on with you. We want you to talk to your mom, to be involved. And if you take the time to really explain some of the nuances and the intricacies, you can often obtain that consent when someone understands the benefits. Um, the other thing too is that the team can let the patient know that the release of information doesn't need to be an all or nothing. So we don't need to disclose every single piece of the person's personal life, but we may talk to them about the fact that, look, what we need to talk to your mom about is the medication you're on, the side effects of the medication, how she might be able to help you with that, perhaps some rehabilitation goals. But if the person says, I don't want my relationship status disclosed, you can put sort of parameters around that. And I think sometimes if you help the person to understand it's not an all or nothing thing, you may be more likely to obtain consent for the pieces that you need to. It's really a need to know kind of basis. And it is important to maintain certain boundaries. And I think that that's been perhaps why some people may be so rejecting, is that they may have had experiences where boundaries have been violated and personal information has been shared that they may not have wanted to have shared with certain relatives. So if we can go to the next slide, Mika. So as Kendra was saying, the treatment team can share general information on treatment and services to a client's families, and also the family themselves may want some support. So they may want that with the patient, or they may want that independent of the patient. So it's important as clinicians not only to assess the actual individual, but to assess the whole system and to understand what everyone's needs are, because families do have a role in the recovery of people. And as we've seen, as the literature is borne out, when families are engaged in a helpful, positive way, the outcomes for clients are better. And people can do that when they themselves feel that they're getting the support that they need and that their questions are being answered, because this is a journey, and there'll be ebbs and flows. And during those times of crises, it is important that people have someone, that family members have someone they can reach out to understand, and also that they have someone to reach out to when they notice that things are starting to perhaps go downhill. And it's family members that will be able to know that, because they will pick up on signs that people who don't know the patient won't. And in fact, they did a study, this is a number of years ago, of case managers who knew patients really well, who had worked with patients for a long time. And they actually paralleled families in their knowledge and in the subtle changes in person. So they could pick up when the person came in their office, say, or in the treatment room, they knew by looking at them that something was wrong. And this is what families know too. They pick up on the subtle signs much quicker because they know the person so well. And that's what the treatment team needs to respect and understand. And then that collateral information becomes so important, because we know that if we can ward off episodes, if we can get people treated earlier and better, then they have less likelihood of having ongoing functional impairment. So the sooner the better in terms of treatment. So if we listen to people who say, look, I know he's not well, I know he's starting to decompensate, then then you can get in there quicker and start to intervene with whichever kind of treatment is appropriate at the time. Okay, so maybe the next slide. So just, CAMH does offer treatment and information to families. And I think, as Alexa was saying, in the virtual world, it's a little more challenging. We're going to have this beautiful place where people can go and, pick up pamphlets from the wall and that kind of thing. It's a little harder now, but it is there through our intranet as well. You can access information, and we do have the Family Center. So we have the Office of Family Engagement and the Family Resource Center, and we have a Family Advisory Committee. Some of you may be members there. And they can be visited and certainly accessed virtually now to gain information. And luckily, in this electronic world, we can make things available to people. So that, I think the next slide is, I hope, a bit of levity. And I think this is a good cartoon. You should have received it by now. We're not allowed to transmit confidential information by telephone, fax, or email. So I sent it telepathically. Just a little bit of irony and tongue in cheek for this, because I think it can seem like that probably at times. So that's the end of our formal presentation, and we're happy to answer any questions. We hope it's been helpful to you.